All right, 10:47. Is everybody back? Well, assuming everybody's back, I guess now I'll turn the gavel over to Mr. Radakovich as the hearing examiner in this case.
Thank you, Mr. Chairman True. Good morning. We are going on the record on docket 24-8 or 4801. Once again, 24-4801. My name is J.D. Radakovich, and I have been appointed to act as hearing examiner in this case. Present today for the council are members Shane True, Marjorie Bedesson, Steve Lenz, Stan Blake, Ryan Green, and Bill Stafford. Also present are council staff Kelly Duran and Joe Girardin, and EQC legal counsel Ryan Shellhaus. We are here today for a hearing on the department's motion to dismiss for want of subject matter jurisdiction. Will the parties please note their appearances for the record? The petitioners. Are the petitioners? You're muted. Still can't hear you, Mr. Edwards.
Good morning, everyone. Can everyone hear me?
Yes.
I'm Kenna Blaney. I'm also appearing on behalf of the petitioners. Mr. Edwards is going to actually join me in my office because for some reason he's having some problems with the audio in his office. So if you could just give us a few moments so he can make the switch.
That's fine. Yeah.
Thank you very much.
I'm assuming you're just down the hall.
Yes, that's correct. We're both tuning in from our offices, but yeah, so
Okay.
Mr. Edwards will
You're in the same building anyway.
Yes, we are.
Okay.
So it should be just a few minutes. Sorry about the delay.
Well, at the end of the day, we're all still subject to Murphy's Law, right?
Can you hear me on this device?
Loud and clear. 5x5. Thank you.
I apologize about that. My computer said everything was good to go and it could hear me on my computer, but I'm not sure why it wasn't coming through. So are we ready to proceed now after my delay?
Yeah, you can feel free to announce yourself as a petitioner for the record.
Right. Thank you. Mitch Edwards with the law firm of Nicholas and Tangeman. And with me here today is our associate, Kenna Blaney. We represent the petitioners, David and Bonnie Schroeder.
Okay, and for the department.
Yeah, good morning, hearing examiner Radakovich. My name is Greg Weiss with the Wyoming Attorney General's Office on behalf of the Department of Environmental Quality, Land Quality Division. Just for the record, with me today are 3 Land Quality Division employees, Interim Administrator Brandy O'Brien and Managerial Supervisory Staff Robin Jones and Craig Holtz. And good morning to you, Mr. Edwards and Ms. Blaney.
Okay, thank you, Mr. Weiss. So this was the date set for a dispositive motions hearing in this case. As a preliminary matter, there is a request from the department to recharacterize the caption in this case. I'm going to remove the word, in quotations, permit from the caption that the council uses. That's just for the record. There's also a motion from the petitioners to strike affidavits filed by the department. I'm going to strike the affidavit. I'm not going to strike the affidavits. However, I'm going to instruct the council not to consider those affidavits in determining this motion to dismiss, as I don't think they are relevant or material in deciding this matter. I will note for the record that the council only plans to take up the department's motion to dismiss today. All other pending motions will be addressed at a later date following this hearing. And following this hearing, I'll meet with the parties to discuss scheduling for those other motions. So for this hearing, the department will have 10 minutes to address the council. Petitioners will have 10 minutes to address the council in response, and the department will have 5 minutes for rebuttal. Just as a note, Kelly or Joe, are you keeping track of time, or do I need to do that on my end, or how do you want that to work?
I'll take care of that, Mr. Hearing Examiner.
Thank you, Kelly. Okay, Mr. Rice, if you're ready, you may proceed.
Mr. Hearing Examiner, before I begin, with due respect, I don't believe 10 minutes is enough to address the important jurisdictional issues. I'll try to keep it to 15 minutes or so if that's a possibility.
I think it's a possibility. Mr. Edwards, do you have any response to that? Just so would you like 15 minutes too, or what's your take on that?
I don't believe I'll need any more than the 10 minutes. I think this is pretty addressed, but if Mr. Weiss would like 15, I don't have any objection to that.
Okay, thank you. Go ahead, Mr. Weiss.
Thank you. So before I begin on my argument, I want to point out a couple of things. It's interesting to me that the first item for today's business meeting was approval of the motion to deny the motion to dismiss and protect our waters Jackson Hole case. I had heard that was going to happen today, and I'm both pleased and a little bit concerned that that happened today, primarily because these two cases are entirely different from one another. We have an entirely different regulatory scheme at issue with a limited mining operation. So I just respectfully ask the council to hear me out on how this case is different from the Protect Our Waters case. And also I'm going to ask the council to note that this case is different from the Wyoming Outdoor Council case that the parties discussed in their briefs. Factually, it's significantly different. In that particular case, the Outdoor Council case, there was a rule that permitted the appeal in question. And as you'll hear me explain today, there's no similar rule that applies to review of limited mining operations. So as I begin, it's important to understand the framework of the Environmental Quality Act. Article 4 of the Environmental Quality Act contains all of the Land Quality Division's jurisdictional authority. And under Article 4, the Land Quality Division has permitting authority over certain issues and expressly does not have permitting authority over certain other issues. And one of those issues, as I will explain, is limited mining operations. There are 8 situations in which the Land Quality Division rules govern land quality permitting and regulation of mining operations. These are set forth in Chapter 2, dealing with regular non-coal mining, Chapter 4, non-coal underground mining, Chapter 5, exploration by dozing, Chapter 7, research and development licenses, Chapter 8, exploration by drilling, Chapter 9, small mining operations, Chapter 11, in situ mining, and Chapter 13, existing bentonite mining operations. Each of these different chapters of the Land Quality Division rules contain express provisions governing permitting of applications for mining of these different types of mining. And under those regulations and the statutes, the Land Quality Division is giving authority to review applications for permits and authority to issue or deny such mining permits. However, under Chapter 4 of the Land Quality Division statutes, and this is Environmental Quality Act, Article 4, there are 6 situations in which certain mining operations and land disturbance situations are exempt, completely exempt from regulation or permitting by the Land Quality Division. And these are set forth in Wyoming Statute 35-11-401E. The first exemption is utility operations, soil conservation practices, and other excavation to construct buildings not used for mining. The next is excavation for extraction of matters such as sand and gravel for construction of highways, railroads, and sand and gravel operations of certain governmental entities. The third is extraction of sand and gravel by a landowner for non-commercial use on their own land. The next is for archaeological operations. The next is for other surface mining operations determined by the administrator to be exempt from permitting processes because of their infrequent and minor nature. And finally, most significantly, the other mining situation, which is entirely exempt from land quality permitting jurisdiction, are limited mining operations. Under 35-11-401E, Roman numeral 6, the division, Land Quality Division, has absolutely no permitting authority with respect to limited mining operations. Essentially and literally, it says right in the statute, the provisions of this article, being Article 4, shall not apply to any of the following activities. And the sixth one that I noted was limited mining operations. So the reality is that for limited mining operations, the Land Quality Division has no authority whatsoever to deny any permit application for any limited mining operation. Its only obligation and authority is to confirm that a bond has been posted for reclamation activities. I mentioned the Wyoming Outdoor Council case a few moments ago. That's significant from the standpoint of timing. In that case, decided in 2012, the courts did deal with the fact that the Environmental Quality Act did not discuss whether a permit could be taken of, or an appeal could be taken of two types of permits issued under the Act. However, as I noted earlier, there was a rule that expressly authorized an appeal, and in that case, the court found that the appeal could be taken. Notably, the very next year after the Wyoming Outdoor Council case, the Wyoming legislature substantially amended the limited mining operation statute. The prior version of the limited mining operation exemption was rudimentary, allowed surface mining operations up to 10 acres, and it contained no real qualification criteria to carry out such operations. However, by its 2013 amendment, the legislature spelled out in more detail the requirements, the statutory requirements that must be met for someone to begin mining a limited mining operation by providing notice to the Land Quality Division. My point is simply this: by the 2013 amendment, the legislature clearly intended that the Land Quality Division not engage in any permitting processes. The legislature made it clear that the Land Quality Division has no permitting authority. And yet, if this council were to entertain the appeal in question, the Environmental Quality Council would be exercising permitting authority over an activity that the legislature has specifically says is exempt from Article 4. And that's the basis for the motion to dismiss. As noted in the motion that was referred to by Presiding Officer Radakovich, a limited mining operation is not carried out under a mining permit. It's simply a notification, and the statute literally says that in order to commence operations in a limited mining operation, all that needs to happen is that the operator has to notify the Land Quality Division of its intent to begin operations, to submit a notification. There's a requirement that adjacent landowners within a certain distance be notified. Notably, in 2020, again, turning to legislative action, the Environmental Quality Act was amended by the legislature to discuss how interested persons could or could not appeal mining permit applications. And those are set forth in Wyoming Statute 3511, 406P, dealing with coal mining, and 3511, 406Q, dealing with objection and appeal procedures for any other mining permit applications, literally the words mining permit applications. And in such instances, the operator for a true mining permit is required to publish notice, and that is not at issue with a limited mining operation. There's no publication requirement. There's no provision allowing the public to file written objections. There is no approval by the department director. And literally, as noted, a limited mining operation is a notification. It says it right in the statute. It is not an application. The point simply being, because it's not an application, the operator can begin work without the approval of the Land Quality Division, so long as the operator submits the reclamation bond based upon the number of acres to be disturbed. I want to talk just a moment about the status of the Environmental Quality Council. I'm sure that all of the members of the council know that the council is a standalone agency under Wyoming law. Under Wyoming Statute 9-2-2013, pursuant to a 1992 reorganization of state government, the legislature created the Department of Environmental Quality, but as regarding the Environmental Quality Council, it specifically said the council shall not be within the Department of Environmental Quality, but shall be a separate operating agency. Why is this important? It's because of the point I made earlier. The legislature, in enacting the LMO amendment in 2013, specifically stated that Article 4 does not apply to limited mining operations. As such, under that statute, the Land Quality Division has no permitting authority over limited mining operations. Yet, if the Environmental Quality Council were to allow these petitioners to carry out this appeal, it would be asserting, the council would be asserting jurisdiction over a matter that Land Quality Division itself does not have jurisdiction over, being permitting of limited mining operations. I pointed out in the motion and the reply that the petitioners in this case could have and should have taken an appeal to a district court under the Administrative Procedures Act. They didn't do that. Obviously, they're trying to bring an appeal before this council. And with due respect to the petitioners, there's an obvious reason for that. Why is that? Because it's much easier to come before the council and carry out an appeal than to file a case in district court to challenge a limited mining operation. And as a practical matter, I can't blame the petitioners for trying to take this appeal. But from a legal standpoint, it's vitally important that the council grant the motion to dismiss and deny the attempt by the petitioners to come forward with an appeal in front of the Environmental Quality Council. The council simply has no authority over permitting or approval of any permit or certification of a limited mining operation. It's just not there. It's not there for the division. And if the council were to be exercising such control, it would be, number one, ignoring the provisions of the limited mining operation statute, and two, interfering with the scheme that both the legislature and the Land Quality Division have put together. There are rules enacted by the Land Quality Division governing limited mining operations, but if you look at those rules in Chapter 10, you'll see there is no provision for an appeal of any action taken by the division to take an appeal to the Environmental Quality Council. And I'll close out by pointing out that if the council were to entertain this appeal and conduct a contested case hearing, the question then becomes what relief would be available to the petitioners. And this is set forth in Wyoming Statute 3511-112, which specifically says what the council can or can't do. It can approve, disapprove, repeal, modify, or suspend any rule or regulation. It can order that any permit, license, certification, or variance be granted, denied, suspended, revoked, or modified. As noted in the division's motion, there is no permit, there is no license, there's no certification, there's no variance that could be granted, modified, suspended, or revoked. Literally, the only thing that could have happened here is the appellants could have gone to district court. And I'll simply point out that it's obvious by the legislature's careful delineation of what relief could be available after a contested case. It's obvious that there is no jurisdiction for the council to entertain an appeal of a limited mining operation situation because the council is statutorily not allowed to take any action over that matter. And so for these reasons and the other reasons set forth in the Land Quality Division's motion to dismiss for want of subject matter jurisdiction, we ask that you grant the motion to dismiss and direct that the council simply does not have jurisdiction to entertain this appeal. Thank you for hearing me out. Thank you for the short extension of time. I appreciate it. And I will now yield the floor to Mr. Edwards. Thank you.
Thank you, Mr. Weiss. Okay, Mr. Edwards, you may proceed. Yeah.
Thank you, members of the council. I appreciate the opportunity to present to you today on behalf of our clients, David and Bonnie Schroeder, who are adjacent landowners to the peat gravel mining operation that is at issue here. The motion before you is a simple motion to dismiss for lack of subject matter jurisdiction. In other words, the department is saying that the Environmental Quality Council does not have jurisdiction to hear this matter or this issue. Subject matter jurisdiction as a matter of law is the power to hear and determine cases of a general class to which the proceedings in question belong. The concept of subject matter jurisdiction is applicable both to courts and to administrative agencies such as the EQC. So to determine what authority the Environmental Quality Council has, we simply need to look at the statute giving the Environmental quality duties and powers, and that's 3511.112. And in particular, subsection A of that section says the council shall act as the hearing examiner for the department and shall hear and determine all cases or issues arising under the laws, rules, regulations, standards, or orders issued or administered by the department or its air quality, land quality, solid and hazardous waste management, or water quality divisions. Clearly, what we are here today about is something that is being administered under the Environmental Quality Act, and it's being administered by the Department of Environmental Quality, and in particular the Land Quality Division. By this statute alone that I just read, the council is required to hear and determine all cases and issues relating to the Environmental Quality Act. Now, if you continue down in the statute, the bottom part of paragraph A, it says the council shall, and then it has a bunch of Romanettes. Romanet 3 is conduct hearings in any case contesting the administration or enforcement of any law, rule, regulation, standard, or order issued or administered by the department or any division thereof. Roman numeral 4 says conduct hearings in any case contesting the grant, denial, suspension, revocation, or renewal of any permit, license, certification, or variance authorized or required by this act. And what we have here is that the Department of Environmental Quality, upon application by Pete Gravel to amend its limited mining operation, issued an approval of that amendment, expanding the operation scope and size, and failed to administer and enforce a consent order that was issued by the Department of Land Quality affecting this particular permit. The order in place provides that the limited mining operations are to be reclaimed to the 10 acres and that they are to be contained to those 10 acres for the life of the mining operation or the permit, whichever is longer. And so clearly the issue that is before this council today is an issue falling under the administration and enforcement of the Environmental Quality Act and orders issued by the Department of Environmental Quality and its Land Quality Division. That should end the inquiry right there, as that is the subject matter jurisdiction of this council. The department argued today that we should have gone to district court and challenged it there. Well, there's a concept that we have to follow that's called the exhaustion of administrative remedies before we can even go to court. Whether that's an appeal from an administrative action under Wyoming Rules of Appellate Procedure 12, or whether that's a declaratory judgment action separate, challenging the statute or the authorization. And so here we are today looking at these statutes and saying who has the jurisdiction to hear the matters of administration and enforcement of the Environmental Quality Act and the orders issued by the Land Quality Division and the department. That is the Environmental Quality Council, and that's why we are before you today. Now, as a interesting point, the statutes that we're talking about with respect to limited mining operations at 3511.401 do set out that it's exempt from this particular standards as they're set forth in that article. That is the permitting standards. But then it goes on to say, in promulgating regulations to implement this section, the administrator and director shall consider the nature of the class, type, and types of activities involved, their magnitude in tons and acres, their potential for adverse environmental impact, and whether the class, types, or types of activities are already subject to existing regulatory system by state or local government or any agency of the federal government. Coincidentally, we find the department's argument interesting because the department has indeed adopted rules and regulations governing limited mining operations. Those are found at Chapter 10 of the land quality non-coal regulations. And so here they're standing before you today saying, we have no authority. All the landowner has to do is submit a notice. They can continue to do whatever they want to do then under that. But the reality is one, the department enforces these laws. The department has regulations regarding these laws. The department has regulations requiring the application and notice and certain things to be provided. And the department, in enforcing those laws, has issued a consent order in this case, restricting the size of the operations during the life of the mining operation or the permit. And so with respect to that, to us, this is clearly within the jurisdiction of the Environmental Quality Council because it is an issue arising out of the laws and administration of orders and enforcement of orders and laws by the department and its division land quality. And so we would respectfully request that you deny the motion to dismiss and find that this council has subject matter jurisdiction over this case and issue. Thank you.
Thank you, Mr. Edwards. Mr. Weiss, any rebuttal?
Yeah, briefly. Thank you.
Understand you have 5 minutes.
I can do it. Thank you.
Okay, thank you.
The provisions of 3511-401 subsection F, as quoted by counsel for the petitioners, do not apply in this case. 3511-401E says, the provisions of this article shall not apply to the following activities. And that's subsection E. Romanet 6 is limited mining operations. That statute says Article 4 doesn't apply. Article 4 begins at 3511-401, and it goes all the way to 3511-437. And the provisions of subsection E6 make it clear the article land quality does not apply to limited mining operations. It says what it says. And as to the idea of relying on section 112 of the statutes, the rules of the Department of Environmental Quality says where authorized by the Environmental Quality Act, appeals to the council from final actions of the administrators or director shall be made within 30 days of notification of such action. That's in the DEQ rules, the rules that govern the council in Chapter 1, Section 8A. The point is there needs to be a specific statutory or regulatory authorization for an appeal. It doesn't exist with regard to limited mining operations. And so while there is the general provisions of 3511-112 subsection A that talks about conducting contested case hearings in certain instances, I think it was subsection Romanet 3, conduct hearings in any case contesting the administration or enforcement of any law, rule, regulation, or standard. That's 3511-112. A, Romanet 3, which is relied upon by the petitioners. That section has to be read in conjunction with subsection C, which is the legislature's specification of the relief that the council can issue with regard to certain activities of the Department of Environmental Quality. And as I pointed out earlier, there is simply no ability for the Environmental Quality Council to issue any relief with regard to a limited mining operation. I can appreciate the idea of exhaustion of administrative remedies, but the reality is that the statute 112 does not provide for an appeal to the council, nor do any other portions of the Environmental Quality Act or Land Quality Division rules. And the reality is that the petitioners could have and should have filed a direct appeal to district court under the Administrative Procedures Act. And so the simple reality is that this is a unique situation. A limited mining operation is a unique situation. Those types of operations have very little oversight by Land Quality Division. It's a notification only process under the statute. And I'll close by pointing out how that works. And I'm quoting from 3511-401 subsection E, Romanet 6. The operator shall notify the Land Quality Division of the Department of Environmental Quality and the Inspector of Mines within the Department of Workforce Services of the location of the land to be mined and the postal address of the operator at least 30 days before commencing operations. And the next sentence goes on to require that adjacent landowners be given a copy of that notice. But as I just pointed out, it's a notification process. They can commence operations within 30 days of providing those notices and posting the reclamation bond required under the LMO statute. The Land Quality Division does not have the authority to issue a permit. All that happened in this case is that the new operator took advantage of the legislature's decision to expand the size of a limited mining operation up to 15 acres in size, because the prior operator of its limited mining operation was fixed at 10 acres. The statutory change in 2013 allowed an expansion to 15 acres. Again, the simple reality is that the council cannot entertain this appeal. With due respect to the council, it would be interfering with the Land Quality Division's limited ability to regulate and monitor limited mining operations if the council were to entertain the appeal. And so with that, I'll simply request that the council grant the motion to dismiss, which will moot the rest of the case. Thank you.
Thank you, Mr. Weiss. Okay. Do any members of the council have questions for Mr. Edwards or Mr. Weiss? I'll just go down the line, I guess. If speak up if you do. Mr. Green, Councilmember Green.
I don't have any questions at this time, Mr.
Okay.
Chair.
Councilmember Blake.
Yeah, I'm still going over my book here, but nothing right now. Thanks.
Good. Councilmember Bedesson. I'll get back to her. Council.
I'm here.
Okay, go ahead.
Slow on the mute button.
Yeah,
But,
I understand. Yeah.
thank you for recognizing me, Mr. Hearing Officer. I understand that from the DEQ's perspective that LMO is not something that goes through the regular permit process. However, it seems that DEQ staff might not understand that legal distinction, in that the previous settlement said when the permit expires, but there supposedly is no permit, and the documents when the notification is received say approval, which you don't approve a notification. Why are there so many documents issued from DEQ that seem to refer to this as an approval or a permit? And so this question is for Mr. Weiss.
Yeah, Hearing Examiner Radakovich, Councilmember Bedesson, thank you for that question. I'm not surprised to hear it. There is some element of approval, if you will, from the standpoint that operations cannot proceed until a reclamation bond is submitted by the operator. And that's the approval that takes place, is an acknowledgement that a reclamation bond has been posted. As to the settlement agreement and why it says permit, I wasn't involved in that. I have no idea why it says it. It's not a mining permit. The statutes, as I quoted in my motion, specifically define what is a mining permit, and that a permit exists only when there's a reclamation plan and a mining plan. And there is no such requirement for those plans for an LMO. So it was a verbiage error, I guess, because it's not a permit. Thank you.
Thank you. That's all I have.
Thank you, Council Person Bedessen. I think Mr. Stafford left the meeting or got cut off, maybe. Is that correct?
Yes, that's correct. Councilmember
Okay.
Stafford, I got a note he had to leave at 11:30.
Oh, gotcha. Okay, thank you. Councilmember Lenz, have any questions for either party?
Thank you, Hearing Examiner Radakovich. I, like the other council members, have probably been reviewing the Wyoming Environmental Quality Act guidebook that we have and followed along with each set of arguments from both the department and the petitioner. And I do not have any questions at this time. Thank you.
Okay. The chair, Shane True, you have any questions for either party?
I do not. Councilmember Bedessen asked the question that I was going to ask, so I don't have any questions.
All right, thank you very much. So I might have a couple questions. One, we've had an LMO brought before the council before, and so I guess I'm kind of confused as to where DEQ's jurisdiction starts and where it ends, because if an LMO operator violates the rules that they're supposed to operate under, what happens?
Yeah, Hearing Examiner Radakovich, I'm taking that question is directed to me.
Yes,
and it's a great question. Under the statutes, this is 3511-701. And you're right, that you have dealt with an LMO before, and I'm going to talk about that in just a second. But in a situation where the Department of Environmental Quality, Land Quality Division determines that a limited mining operator is not following the statutory requirements, under Section 701, the Land Quality Division is directed to issue a notice of violation to that operator, specifying the violation that's taken place and what action is needed to remedy the violation. Under 3511-701, if a notice of violation is issued, it becomes final unless the permit, not the permit holder. Well, it applies to both permit holders and operators such as a limited mining operation. The LMO holder under Section 701 can contest the notice of violation in front of the Environmental Quality Council. That's one instance when the operator, not a member of the public, but when the operator can come to the council and say, I've been given this notice of violation and we want a hearing before the council. In that circumstance, the Environmental Quality Council can agree or disagree that a violation has taken place. The other instance in which an LMO can come before the council is if the Department of Environmental Quality determines that it needs to forfeit the reclamation bond. And there are provisions, again, in the Environmental Quality Act that say when a bond forfeiture is requested, that's done through the Environmental Quality Council. And you have done that recently in the quality landscaping case. I'm familiar with that. In that case, there were notices of violation issued to the LMO operator. And ultimately, the department decided to forfeit the bond, initiated an action before the council. The council upheld the division's determination that violations had taken place and ordered that the bond be forfeited. So I'm not saying that an LMO will never come before the council. I am saying that there is no appeal of I guess what I would call the startup of the limited mining operation available to a member of the general public under the Environmental Quality Act. There are other specified limited circumstances in which the council can deal with issues pertaining to a limited mining operation, but not the approvals per se of any such situation, because as I noted, the LMO statute provides only for a notification to the division. Thank you.
So another question, and then bear with me here for a second, but and I don't want to put words into your mouth, Mr. Weiss, but I'm wondering if some of the semantics or wording that the DEQ has used over time just hasn't kept up with the legislation that's occurred in recent years, or is it a time and timing thing of when these documents were completed, or because the hang up here is, the amendment was approved by DEQ. So, do you have authority or do you not? And if there's a problem, then the DEQ steps in, and there's a lot of confusion around this as to what role you guys play in LMOs, and therefore what role we're supposed to play in overseeing how you guys treat those.
Yeah, that's a good question. As I noted before, the division's approval authority relates to the reclamation bond that's required by the LMO statute. As for the other components of the limited mining operation, as I noted, the legislature indicated in 3511-401E, Romanet 6, subsections A through G, the specifications that govern the operations of the activity, the mining operation in question. And so from a purely ministerial standpoint, if someone were to submit an LMO notification to disturb 20 acres, which is beyond the statute, in such a scenario, the Land Quality Division would have the ability to notify the operator that it can't carry out operations on 20 acres, and then the LMO would be fixed at a maximum of 15 acres. So the Land Quality Division's regulatory authority, if you will, is to ensure the compliance with the statutory standards that are spelled out. And so literally what can happen is if an LMO is submitted to disturb 20 acres, the division could say you can only operate up to 15 acres under the statute. It's not an approval or disapproval. And if the operator were to begin disturbing more than 15 acres, then the division could carry out an enforcement action, issue an NOV under section 701. And ultimately, if there's no hearing in front of the EQC because the operator doesn't initiate an appeal, then under section 901 of the Environmental Quality Act, the division could pursue monetary penalties against the operator for violation of the act. And so it really is a unique situation. I appreciate the questions from the council. It is unique. It really is unique. And as I indicated, I don't fault the petitioners for trying an appeal, but the reality is that the legislature put together this process to facilitate, frankly, small sand and gravel operations without a permitting process, and said, do these following things and you're good to go. Just notify the division.
Thank you,
And
Mr.
that's
Weiss.
where you carry that out.
Mr. Edwards, did you want to respond to my previous question?
Yes, sir, I would. I was just gonna, if I may, follow up just briefly with the idea of the DEQ enforcing, and Council Weiss pointed out that if there's a violation of an LMO authorization, and the statutes and the regulations that the DEQ's put in place with regard to that. Under 701, an NOV would be issued. And that's also part of what we're dealing with in this case. Is there was an NOV issued to the operator of the LMO under 701 that resulted in a consent order being entered that has the restriction on it. The department is tasked with enforcing and administering those orders that are issued under 701, which goes back to the jurisdictional element that we're talking about, where the council is to hear issues regarding the administration and enforcement by the department of orders. And so that's part of what is part of this appeal. But I think we're trying to split hairs here with the department saying, well, we have the authority to regulate by creating regulations specifically for limited mining operations. We've done that. We have the authority to do the enforcement. We have the authority to say, we're approving this, we're approving the reclamation, which is required to happen. We're approving the reclamation bond, but we don't have any authority whatsoever. It's just a notice. Either they have authority or they have no authority whatsoever, and there shouldn't be any rules, regulations, enforcement, etc. Because what they're enforcing here is their rules and regulations and the statutes that are applicable to limited mining operations. Thank you.
Thank you. Let's stimulate any other questions from council members. Please speak up. Going once, going twice.
Hearing Examiner Radakovich, one clarification, if I may. I promise to be brief.
Okay.
The division has revised its documents to deal with the question raised by Council Member Bedessem as far as the approval. And simply what's happened now is that the division has modified this process simply to acknowledge the notification of an LMO submission, to get rid of this ambiguity that might be created by the word approval. Thank you.
Okay, thank you. Thank you all for your input on this matter. I'm going to close this hearing and turn the gavel back to Chairman True, our presiding officer. Thank you very much.
Thank you, Vice Chairman Radakovich. Okay, now it's in our laps. So the council has now had an opportunity to review the filings. We just heard oral arguments from the parties and asked any questions that we may have had. So now I'm going to ask for a motion on this matter. Do I have a motion to approve the department's motion to dismiss for want of subject matter jurisdiction? Or deny, whatever the feeling of the council is.
Mr. Chair, I'll make the motion to approve the motion to deny. This is Councilmember Green.
I would like to second that.
Thank you, Councilmember Green. Do I have a second?
I would like to second that.
Thank you, Councilmember Bedessem. Before I forget, I do want to acknowledge that Bill Stafford did leave at about 11:30 a.m. and he was excused, though we still have a quorum and we'll still proceed. So now that we have a motion to approve the department's motion to dismiss for want of subject matter jurisdiction, we now need to open this up to discussion. So are there any council members that wish to provide some discussion?
Mr. Chairman, I just want to be clear on Mr. Green's motion. Was it a motion to grant the motion to dismiss? Or, okay, so it was a motion to grant the motion.
Well, yeah, that's my understanding.
Yes, that's correct.
Agreement was to approve the motion. Okay.
That's correct.
Yes. So any discussion? Okay.
Well,
I can make a comment.
Okay. Councilmember Bedessem, you're recognized.
Thank you. In deliberating about this particular case, I think for me, my biggest concern was the ability of the council to provide petitioners with any relief relating to the LMO. And we're limited to, quote, approve, disapprove, repeal, modify, or suspend any rule, regulation, standard, or order of the DEQ director. And so the difficulty I have with that is that I don't see that if we took this case that I, as a council member, would have good options for relief. So, so as a result of that, I'm more comfortable with approving the motion to dismiss so that the petitioners can take their particular case to district court should they wish. Thank you.
Thank you, Councilmember Odessa. Any other discussion? Going once, going twice. Okay. Hearing none, discussion is closed. I will now call a roll call vote on the motion to approve the department's motion to dismiss for want of subject matter jurisdiction. And this will be a roll call vote. And we'll start with Councilmember Green.
Aye.
Councilmember Blake.
Aye.
Councilmember Bedessen.
Aye.
Councilmember Radakovich.
Aye.
Councilmember Lenz.
Aye.
Councilmember Stafford is excused, and the chair also votes aye. So the ayes have it and the motion carries. So the council will issue a written order on this decision. Do we have any administrative business to go over, Kelly? Or
Mr.
anything?
Chairman, I just wanted to make the council members aware that there's some annual reporting requirements that are required of the members of the council. I'm going to be sending out some forms probably today or tomorrow for your electronic completion and signature. So just keep an eye out for those.
Thank you, Kelly. Is there any for executive session on any other legal advice, personnel matters, anything? I don't think there is. Hearing none, then I want to thank everyone for your attention on these matters. And this concludes all the items on our agenda. Do I have a motion to adjourn?
I'll make that motion.
And I'll
All right.
second that, Mr.
All right, we
Chair.
got a motion to set all those in favor of adjourning, say aye.
Aye.
And all those opposed, and I don't hear anyone. So the meeting is adjourned.
Merry Christmas, everyone.
Merry
Merry
Christmas.
Christmas.
Have a
Thank
good
you,
one.
guys.